Record shall now show that all parties are present and the jury is present. Anything to bring up further by the parties, state?
No, Your Honor.
And Mr. Peoples on defense. Anything further? There is no answer. Earlier I asked and Mr. Peoples said, I wish I could change the world. So I'm going to move forward here. And at this time, the court will read to you the jury charge of the court, which contains the law applicable to this case. Ladies and gentlemen, in continuing to discharge your responsibilities as jurors, you must continue to observe all the instructions previously given to you. These instructions are given to you because your conduct is subject to review, the same as that of the witnesses, parties, attorneys, and myself. Please listen carefully, as I know you will when I read this charge to you. It will be left with you to refer to as necessary during your deliberations, ladies and gentlemen. Members of the jury, the defendant stands charged by indictment with the offense of aggravated assault against a public servant alleged to have been committed in Jefferson County, Texas, on or about June 6, 2023. The defendant has entered a plea of not guilty to this indictment. Our law requires that I submit the following charge to you in this case. This charge contains all of the law necessary to enable you to reach a verdict. If any evidence was presented to raise an issue, the law on that issue must be provided. Definitions. So that you can better understand some of the words and terms used in the charge, the law provides the following definitions. Assault. A person commits the offense of assault if he intentionally or knowingly or recklessly causes bodily injury to another. Aggravated assault with deadly weapon against a public servant. A person commits the offense of aggravated assault if he commits assault against a person the actor knows is a public servant while lawfully discharging an official duty. Bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Public servant. Public servant means a person elected, selected, appointed, employed, or otherwise designated as an officer, employee, or agent of the government, even if he has not yet qualified for office or assumed his or her duties. Correctional facility. Correctional facility means a place designated by law for the confinement of a person arrested for, charged with, or convicted of a criminal offense. The term includes a confinement facility operated by the Texas Department of Criminal Justice. Deadly weapon. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Intentionally. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. Knowingly. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Recklessly. A person acts recklessly or is reckless with respect to a result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the defendant's standpoint. Charge. Now, if you believe from the evidence beyond a reasonable doubt that in Jefferson County, Texas, on or about June 6, 2023, the defendant Raymond Peoples did then and there intentionally, knowingly, or recklessly cause bodily injury to Charles Ford by striking Charles Ford about the head or body with pens, and the defendant did then and there use or exhibit a deadly weapon, namely pens, that in the manner of its use or intended use is capable of causing serious bodily injury or death during the commission of said assault. And the defendant did then and there know that the said Charles Ford was a public servant, namely a Jefferson County corrections officer in the lawful discharge of an official duty, to wit, transporting said defendant with the correctional facility you shall find the defendant guilty of the offense of aggravated assault against public servant. Stand by. Unless you so find, or if you have a reasonable doubt thereof, you shall find the defendant not guilty. After the attorneys and the defendant present their arguments to you, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during your evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision or decisions, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case in accordance with the law and the evidence. There are two options you have. One, we, the jury, find the defendant guilty of the offense of aggravated assault against public servant as charged in the indictment, placed for the foreperson to sign. Your other option, we, the jury, find the defendant not guilty of the offense of aggravated assault against public servant as charged in the indictment, a place for the foreperson to sign. Of course, only when jury form can be signed. Under the rules, the state of Texas may open and close final arguments. What says the state?
State of waive its right to open, reserve its right to close, Your Honor.
Okay, the state has waived its opening. Mr. Peoples, you can move forward and give your final argument now.
During the video, during examination of the video yesterday, you all seen and witnessed that when I exited the cell, I never swung or struck anybody with those pins. Even more so, what's the name? Sergeant Anderson blatantly said I struck Lieutenant Ford with the pins after Lieutenant Ford admitted that his injury came from my fingernail. You also heard the testimony of everybody that say they don't remember seeing me strike Lieutenant Ford at all with the pins. 5 people was there. Only one person said that. 4 people is not gonna mistakenly miss something so explicit, especially the way it was strapped to my hand. Clearly, I was doing what I was doing to deter his actions and discourage the constant harassment. Clearly, that didn't work. So, being that didn't work, I obviously had no intentions on stabbing him. When I grabbed his face, I could have gouged out his eyeballs. I didn't do that. Clearly, my intentions wasn't malicious. I just simply wanted the cell cleaned, which by law, that's cruel and unusual punishment to force somebody amongst something like that. But yet, everybody, exhibit 1, 2, no, I forgot which one it was. But after I showed, what's his name, Detective Gardner, his report, he said he did write this or whatnot. And one of the papers is he stated in his report, Lieutenant Ford indicated in his report that Peoples exited the cell holding a pen in each, and holding the ink pen in a manner to use as a deadly weapon, but he believed the visible injuries he received come from Peoples' fingernail. His aggression was focused on Lieutenant Ford as he used the ink pens to cause several lacerations on Lieutenant Ford's face, neck, and upper chest. Several of the wounds were close to Lieutenant Ford's right eye and could have resulted in more serious bodily injury. So, regardless of how they manipulate the law on the instructions, the indictment is clearly stating that I stabbed him. His probable cause affidavit is clearly stating that I stabbed him. His report explicitly demonstrates that I stabbed him. The indictments express that are threatened with imminent bodily injury, which would be force of a violent nature, right? Which would be assault, not aggravated assault. Aggravated makes it becomes aggravated when you use a weapon. Simple as that. Or cause serious bodily injury. One of the two. Use, not just exhibit a weapon, not just hold a weapon. When you exhibiting that weapon, you have to actually use it. If you have a knife in your hand and you cut somebody, that's using it. If you have a gun in your hand and you shoot somebody, that's exhibiting it while causing serious bodily injury. If that bullet hits them, exhibiting it is merely a description of a remote injury. That's it. A threat to cause death or serious bodily injury by the production of a weapon or otherwise, as long as the act or purpose is limited to creating the apprehension that he will use force if necessary, does not constitute deadly force, which would be aggravated assault. Penal Code 9.04, Texas Penal Code 9.04 is what that
Sorry, I'm
was.
gonna have to object. He's stating law that's not in the charge and is not before the jury.
The objection is sustained. Ladies and gentlemen, you can only consider what is within the jury charge and the law that the court has given to you. That is what the law states. It's in the judge's domain, the law to be given to you based upon the law. The parties are not allowed to supplement the law during final arguments, or to change indictments or to change the laws. So your objection is sustained. Move forward, sir. Thank you.
A person commits an offense if he recklessly engages in conduct that places another in imminent danger of serious bodily injury. The production, reckless and danger are presumed if the actor knowingly pointed a firearm in the direction of another, not whether the actor know or not. That's what I have 20 years for.
I'm sorry. Once again, if two people speak over each other, when an objection is made, Mr. People, you have to stop. You will have an opportunity to complete what you need to say for the record. The objection is sustained. Did you want to add anything else, sir?
Yes.
Okay.
So I want you guys to be aware that so the day that the judge violated my probation, gave me 20 years for the aggravated sexual assaults or whatnot, and then I went to trial afterwards and found and it was found not guilty.
Hold on. Yeah.
I want you to understand
Sir,
that
hold
was
on.
double jeopardy.
Hold on, sir. Hold on, sir. So the jury understands this court doesn't violate anybody's, not violating anybody's probation. If someone is on probation, a motion to revoke probation is filed by the executive branch of government. It's not a jury trial. A motion to revoke probation gets heard strictly, exclusively by the judge, and the judge makes its determination based upon whether it's a preponderance of the evidence standard or beyond a reasonable doubt based upon the circumstances. But just so that you understand, so that you're not confused, this court doesn't violate anyone. And in the way that term is used properly in English. But if someone is on probation and violates probation and there's a hearing and the court finds that enough hearing supports the allegation of violation, then the court can grant the motion to revoke probation, then find the defendant guilty, and then the court has the authority to set a sentence based upon additional information that the court may receive for sentencing. That is the way that works. But once again, just so that you don't, so that you're not misunderstanding, this court doesn't violate a human being. I don't violate people. That's misuse, and I don't want you to misunderstand. But a person on probation, if they violate the terms of probation, not me, but if a defendant does, by proof, then the court can revoke probation and sentence a defendant. That's the way that works in motions and revocations of probation. This is not a revocation of probation here. This is an indictment separately alleging what you've heard throughout this case and what was read to you and what the court instructed you on under its instructions. All right, Mr. Peoples, you may go forward.
And yes, the judge is right. A court may violate a person if they're on probation or whatnot, if they have jurisdiction of that charge that they're violating that person on. But if they never had jurisdiction in the first place and that charge wasn't supposed to be in their court, they was never allowed to violate. It wasn't sanctioned. That act wasn't sanctioned by law at all. Actually, that's an understatement. They never had any legal right, period. No power to violate that probation. Correct, Judge? Is that correct? Is that right?
I believe the jury is making a determination on the indictment, sir.
Right.
The probation, any probations are not part of this case. Please strictly stand by what's been charged so that the jury
Right.
is not confused. Thank you.
So
Let's stay with the indictment and the proof for this indictment. Thank you,
Right.
sir.
on this indictment, they plan on giving me 15 years to life because of my prior conviction, which the judge never had authority to convict me on in the first place. Is that correct, Your Honor?
You're asking me a question, sir?
Yes.
No, move forward. This court has not been reversed in your cases. No, the decisions made in your cases have been final and approved and affirmed. Move forward with this argument. Thank you,
I
sir.
was just asking, was my interpretation right of the indictment that I have now?
We're talking about the indictment. There is a presumption of innocence, and I wrote the lead article in the state and law on the presumption. That's sacred. The presumption of his innocence exists unless the jury decides proof has been proven beyond a reasonable doubt otherwise. That's the rule of law. Go forward. Thank you.
With two of those charges being one being dismissed and the other one being found not guilty, I will be being held without indictment, right? The fact that I'm doing 20 years in prison for those violations, for those sexual assaults, will mean I will be getting held without indictment, seeing that two of them don't exist anymore. Correct?
Your Honor, I'm going to object. If Mr. Peoples stick to arguing this case, he can do his appellate work with the appellate court, which he's already done.
All right. So
Those rulings have already been sustained by appellate courts. Let's move forward on this case. Thank you.
all right. Witness against. Right. Anytime a witness themselves, the witness themselves, right? Not a prospective witness, but the witness themselves, the victim, admits to the contrary of the indictment. I mean, the Sixth Amendment would be getting violated when it says the accused shall be confronted by the witnesses against him. So if the court says that the jury is bound by the law, right? You know, for the love of God, right? By law, I'm not supposed to be convicted of this crime. Correct, Judge? Or did I
You don't ask the court questions during final argument. You know that, sir.
Oh, I
Make your final argument.
I just thought you were going to.
Thank you, sir.
The implements for an escape. The fact that the detective himself wrote that on one of his reports that the victim believes that he was scratched. And then on the other one, he admitting that I told him I had no intent, nor do he have any evidence of any intent to escape, right? And makes that those two factors also makes both of these indictments illegal. So, you know, that's pretty much all I got to say about this. And and also the law says whoever knowingly have knowledge, whatever officer knowingly have knowledge of the illegal confinement of the person that they have detained, shall issue the writ without delay. Code of Criminal Procedures 11.15. And it is his duty to issue the writ without delay. That's 11.05. Penal Code, not Penal Code, Code of Criminal Procedures 2.03. The state, the prosecutor, the judge, and the attorney represent the defendant, what are all attorneys, all court officers shall conduct themselves to to seek justice, not impair the ability of the accused to prove his innocence. 2.03 Code of Criminal Procedures. I'm done.
All right, statement close.
Got pretty patient this last few days. I hope you could appreciate the tightrope I've been walking, trying not to overdo that lawyer stuff and try to help Mr. Peoples when I can. But there comes a time when we gotta look and say, you know, all this stuff that he's been doing, he's already done in appellate courts and everything else, and they've all denied him, and so he's just he doesn't get his way, and so he keeps saying it over and over, just like he did with the lieutenant, hoping he'll get a tray. And I get tired of it because what he did that day on June 6th of 2023 was a violent act. And you cannot deny that, because if you deny it, then you have to say, I don't recognize the fact that he wrapped his hands in cloth, getting ready for battle with pins in them, and came out of that cell with his mattress out in front of him. Why did he wrap his hands with cloth and put pins in them? And why was he coming out of the cell with those if he wasn't intending to harm anyone? Second, you heard Lieutenant Ford say in his testimony that when Mr. Peoples reached for his face, lunged at him, which you've heard a couple of them say, lunged at him with his hands, he still had those pins in his hands and all he felt was pain. And yes, there's some scratches on there, but you also see that little sharp one. And that's where Arliss Anderson saw, standing right next to where Lieutenant Ford was struggling with this man, who all he had to do was say, I'll go down to the other cell. And he had a chance with Mr. Darby up here on the stand. You remember Mr. Darby walked all the way down to that cell and stuck his head in there, was in there for 30, 40 seconds looking around. And he did not come back and say, yeah, you're right. Because he could have asked him that while he was on the stand. And none of that ever happened. Darby said he went down there, looked, and the cell was fine. And all the officers went down there with him afterwards and said the cell was fine. So all that stuff he's doing is just a smoke screen, just like it was for that when he threw himself on the ground because he didn't get a tray. He doesn't get his way. And so he starts just doing anything he can to try to get his way. It's all about Mr. Peoples. Everybody's out to get Mr. Peoples. The appellate court's out to get Mr. Peoples. The judge is out to get Mr. Peoples. I'm out to get Mr. Peoples. I even have some influence with the Supreme Court of the United States and the Court of Criminal Appeals. I don't know where that comes from because I've never even been to the Supreme Court of the Court of Criminal Appeals, but evidently I have influence there. I've wrongfully indicted him, wrongfully convicted him. He's doing 20 years in prison for something that he shouldn't have done. And he won't even accept responsibility for that, even though he knows he pled guilty to it. And we'll cover that later. But he can't just say things. He can't just come up here and say things, because everybody in that whole unit said that he came out with those pins and was spoiling them around. They didn't see who he hit. A couple of them didn't see it, but Arliss Anderson saw it. Lieutenant Ford saw it coming at his face, and those pins were there. The wrapping was there. Everything's there that said happened. And you don't have to agree. You need to know that under this law. And you can look at the law. You do not have to agree on whether you think he did it intentionally or knowingly or recklessly. Some of you can think he did it intentionally. Some of you can think he did it knowingly, knowing he might cause injuries. And some of you can think he did it recklessly by the fact that he did it, because all that is an aggravated assault, and it's against a public servant who's doing a lawful duty. That cell was being decommissioned. You've heard them all say it. They have to follow certain standards. They were decommissioning that cell. They had to do some work on it to make it safe for them. And then you get back to, why do you have to do stuff on cells? Because he even introduced it in here. People get out of their cells to attempt to escape. This man did. He introduced it himself. In this cell, plugged up the cell lock and walked out and was wandering around the cloud in a trustee uniform, walking around with a blanket where he could get out. All that's the stuff he was introduced. So y'all need to think about this. This man does not tell the truth. He gets up here and lies. He lies to them about the trace. He lies to them about the phone calls. He lies to you about the law. He's just doing anything he can to get his way. Don't get him his way. Don't reward him for being the person that he is. These people that have to protect you while they're watching people in jail, prisons, they have enough to put up with just dealing with the day-to-day stuff and making sure that everybody's safe and everybody gets what they want. But then they have to deal with people like Mr. Peoples. This gentleman over here does nothing but cause them misery, heartache. You heard them. They all have dealt with him. Even Lieutenant Tinker,
bless his heart, you could see him trying to be nice and just come on down and get in yourself. And what's he doing? Grabbing the cell, holding on, arguing, and then he starts yelling those words. And I want y'all to remember those words he was yelling from inside that cell. I'm going to kill. Now, I'm not going to repeat the N word that he used.
Don't.
That was being yelled out by this man in that cell. Why would you yell that out over a stupid tray that came from Tuesday on a Sunday? And you don't get your Tuesday tray on Sunday? They don't do that. And the lieutenant ended up giving in to him and giving him a tray. It just rewards him. So I'm asking you, when you go back here, you look at this, it's apparent from the injuries on Lieutenant Ford. And I'm not going to harp on them. But you do need to remember why we're here. We're not here because he didn't get to go get his way. We're here that right there is not from a fingernail. This right here is not from a fingernail. Those are sharp instruments coming down, and it didn't come down because he was trying to distract him. He was trying to get him in the eye, guys. Trying to poke him in the eye, and he missed. That's why it came down here, and it's down here all the way down because he was swinging. So don't feel sorry for him. You should feel sorry for Lieutenant Ford, who has to go through that every day with this man. Don't reward him for being the way he is. That is not what you do with people who throw fits and try to hurt people in jails that are just trying to make sure everybody's safe, including the people outside the jail. If they're trying to get out, they're trying to harm people in the jail. Do you really think those guys, that this is that important, that all those people would take time out, even people that left, if this man didn't do something that serious? Why did they come up here? And Lieutenant Ford, if you want to think he's a liar, wouldn't it have been easier for Lieutenant Ford to say, hey, I saw him stab me in the eye. He was trying to get me. I saw him swing at me several times. Wouldn't that make more sense if he was trying to lie about this instead of I saw his hands coming at me and then I felt pain and I don't know, fingernails or what? Arliss Anderson, who doesn't have anything against him. You didn't hear one thing about Arliss Anderson causing him any problems anywhere else. Comes in here and says, I saw him do it. And then, if you want to know what kind of person he is, just look at all the stuff he even admits to. Throwing stuff on people. Totally causing havoc in that jail. He needs to be put back in prison. So if they don't have to deal with him, we don't have to deal with him. He needs to go away. But right now, all we need to do first is talk about finding him guilty. Hold him responsible. Don't listen to his wanderings and meanderings. Hold him responsible for what he did that day. Then you can talk about punishment later on. You can adjust it however you think it is. But don't let him just walk away from this. You know what that does? That tells him, you know what? Go do it again. Throw all the fits you want. Do what you want. Then come in here and just go, oh, they're all against me. And everybody just let him go. Go ahead, let him go. If you want him to do this again and just keep on doing this, let him go. Feel sorry for him. Or you can say, you know what? Enough's enough. You don't rule this world. You don't get to rule the jail. You don't get to rule this day. And you don't get to rule this court. No matter how hard you try. Hold him responsible. Find him guilty. And then let's get on to the next part. And you can do what you need to do there. Thank you.
All right. Ladies and gentlemen of the jury, this time I'm tendering the jury charge to the bailiff. I'm going to ask you, please step down from the jury, follow the bailiff into the deliberation room. We will await your verdict. By rule of law, only 12 people are allowed in the jury room by law. That means the alternates have to stand out, hold vigil, don't stand up, go outside, relax, stretch your legs. We've had to replace jurors during deliberations before. That's why by law we keep you until the end. But thank you. And you never know, we may be able to pull you into the game here before the end. Thank you for bearing with us. And the record shall show that the jury is in the courtroom. All parties are present. And you, sir, are going to be, your name, I'm sorry.
Dalston.
Okay, stand by. Yeah, you are juror number 28 on this. You are the foreperson of the jury. We have received a message on behalf of the jury that the jury has reached a verdict in this case. Is that true, sir?
Yes, sir.
Is this verdict a unanimous one? That is one that is agreed upon by all members of the jury.
Yes, sir.
Do any of the jurors, fellow jurors, disagree with your foreman's representations? No disagreement is indicated. It does appear to be unanimous. I'm going to ask you pass the documents to the bailiff. I'm going to review for proper form, and I will publish the verdict. And in cause number 23, the defendant shall rise, please. In cause number 23, CR 727. We, the jury, find the defendant guilty of the offense of aggravated assault against the public servant as charged in the indictment, signed by the jury foreperson. And this again is 23 CR 727, the state of Texas versus Raymond Peoples. The jury verdict is received. It is made a part of the record for all purposes. Ladies and gentlemen of the jury, at this time I have received and accepted your verdict finding the defendant guilty of the offense as charged in the indictment. That brings us to a close of phase one of this two-phase trial. We will be proceeding with the punishment phase next. And let me repeat once again, you still are under all instructions previously given to you. Is the state and the defendant ready to move forward with the punishment phase of this trial, state?
Yeah.
And Mr. Peoples?
Yeah.
All right. We've received the verdict on the punishment phase of this trial, and we will bring the jury in to receive the verdict. And the record shall show that the jury is seated in the courtroom. And Mr. Stanley, as foreperson of the jury, we've received a message on your behalf stating that the jury has reached a verdict in this punishment phase of this case involving Raymond Peoples in cause number 23 CR 727. Is all of that correct, sir?
Yes, sir.
Is this verdict a unanimous one? That is one that is agreed upon by all members of the jury.
Yes, sir.
Any of the jurors disagree with your foreperson's representations? No disagreement is indicated, and it does indeed appear to be unanimous. As before, if you would pass the documents to the bailiff, I will review for proper form and publish the verdict. All right, the defendant shall rise. In cause number, the defendant is refusing to rise, for the record. In cause number 23 CR 727, the state of Texas versus Raymond Peoples, we, the jury, find that prior to the commission of the offense for which we have found the defendant guilty, the defendant was previously convicted of a non-state jail felony offense as alleged in the indictment, and assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 40 years, signed by the jury foreperson. The verdict is received and made a part of the record for all purposes. Ladies and gentlemen of the jury, at this time, your duty as jurors is completed. At the beginning of the trial, I placed each of you, releasing you from all those instructions previously given to you. However, one final instruction: once you are discharged, you are released from your oath of secrecy. Once you are released, you are free to discuss these matters as you choose and free not to. I want to thank you for your service as jurors, and it's the way the Constitution works. We, the people, get to make these decisions on other people's lives, and I think that is the proper way to do things. I hope to have the honor to work with you in the future. May God continue to bless Jefferson County and her citizens, and you are excused. Thank you. You are going to have documents.
If they'll wait for me out front, I'll have their excuse letters for work or school.
Okay, she'll be out shortly. Thank you. All right, in 23 CR 727, is there any legal reason why judgment shall not be formally assessed at this time?
Oh, yeah.
State or defense? No response from Mr. Peoples. Mr. Peoples, Raymond Peoples, you came before this court and a jury, entered a plea of not guilty to the offense as set out in the indictment. The evidence was submitted. The jury was charged by the court. After deliberating, the jury returned a verdict finding you guilty of the first-degree felony of aggravated assault against a public servant. Thereafter, evidence was presented on the punishment phase. The jury was instructed on the law on punishment during their deliberations. After deliberations, they assessed punishment at 40 years confinement in prison. It is therefore the judgment of this court that you are guilty in this cause number 23 CR 727. and you shall be punished in accordance with the jury's verdict. Is there any legal reason why sentence should not be pronounced against the defendant by either party?
No, no.
Finding nothing to bar the pronouncement of sentence against you, it is the order of the court that you, Raymond Peoples, who has been adjudged to be guilty of the offense of first-degree felony of aggravated assault against a public servant in this cause number 23 CR 727, and whose punishment has been assessed at 40 years confinement in prison in the Texas Department of Criminal Justice's Institutional Division, shall be delivered by the Sheriff of Jefferson County, Texas, to the Director of the Texas Department of Criminal Justice's Institutional Division, or any other person legally authorized to receive such convicts, where you shall be confined for 40 years in accordance with the laws governing the Texas Department of Criminal Justice's Institutional Division. Under Article 42.08 of the Texas Code of Criminal Procedure, the law states if a defendant is sentenced for an offense committed while the defendant was an inmate in the Texas Department of Criminal Justice and serving a sentence for an offense other than a state jail felony, and the defendant has not completed the sentence he was serving at the time of the offense, the judge shall order the sentence for the subsequent offense to commence immediately on the completion of the sentence of the original offense. What does the state say?
Judge, it's pretty clear that this person was, Mr. Peoples was serving a 20-year sentence and was still under the custody of the Texas Department of Criminal Justice. So it's mandatory to be stacked. We'd ask that you stack it on top of this prior sentence in clause number 16-24808.
All right. Your objection is made. It is overruled. The law is clear under Article 42.08. So you are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 40 years. And that sentence of 40 years shall commence immediately on the completion of the sentence. For 3 years. You're going to have to stop him from speaking so we can complete this. As obstreperous as he's been through the whole trial, he continues to interrupt the court. The judge, under the law, orders, and this is cause number 16-24808.
That's correct.
That the court finds that the defendant was an inmate in the Texas Department of Criminal Justice serving a sentence for the offense of aggravated assault, a second-degree felony, convicted on April 22nd, 2021 in cause number 16-24808 in a conviction in this criminal district court of Jefferson County, Texas. He has not completed the sentence he was serving at the time of the offense that he has now been convicted, this first-degree felony of aggravated assault against a public servant as adjudged by the jury. Thus, the judge is ordered to sentence the defendant of this subsequent offense. He has now been found guilty in 727, which was committed subsequent to the conviction he received in cause number 16-24808 of the second-degree felony of aggravated assault. The judgment shall state that this offense here, the sentence in 23 CR 727 of 40 years confinement in prison, shall commence immediately on the completion of the sentence the defendant is serving in cause number 16-24808, the aggravated assault second-degree felony. And thus, this sentences shall run cumulative or consecutively to each other by law. The defendant will be given credit for all time he has served in accordance with these sentences, and that is the finding of the court, and that is the ruling. Anything else to add, state or defense? We're in recess. You are here You are now remanded to the custody of the sheriff of Jefferson County, Texas, until she can obey and carry out the direction and instructions of this sentence. That is all.